I built a dam to protect my land from flooding. The HOA called it an eyesore and fined me $400. Karen wanted it gone by Friday. No exceptions. I begged for more time. 3 months later, worn down, I finally gave in. I opened the dam during their biggest golf tournament of the year. What poured out exposed a secret Karen never wanted anyone to find. My name is Ethan Cole, 36 years old, a civil engineer who spent his career keeping water where it belonged. My wife Mia and I bought our 5 acres in Willow Creek Estates outside Millbrook, Ohio, 3 years ago, drawn by the open land behind the house and the creek that cut through the back corner of our property. We had a daughter on the way and a plan. Raise Lily somewhere quiet, somewhere with land enough to build a life instead of just a house. The creek flooded twice our first spring, swallowing half the yard. I designed a small retention dam myself, permitted through the county, to hold the runoff before it reached our porch. Willow Creek Estates sold itself on freedom, 5-acre lots. No shared walls, room to breathe. What the brochure didn't mention was the HOA, run for 11 years by a woman named Karen Whitfield, who treated every gravel driveway and mailbox color like a referendum on her authority. Karen lived at the end of Magnolia Court in the biggest house in the development, with a husband named Richard who was rarely seen and a black SUV that idled in driveways while she inspected lawns. Neighbors joked about her behind closed doors. Nobody joked about her to her face. The HOA newsletter, which Karen wrote herself, ran monthly compliance spotlights, naming homeowners by address for infractions like unmowed grass or an unapproved shed color. People called it public shaming. Karen called it accountability. Either way, everyone on Willow Creek knew better than to end up in that column. My dam sat on the back corner of my lot, mostly hidden by a stand of oaks, visible only from the 8th fairway of Millbrook Ridge Golf Club, which bordered our subdivision. I'd gotten a county floodplain permit before pouring a single yard of concrete. I kept the paperwork in a drawer, never imagining I'd need it. For 2 years, nobody said a word about the dam. Quietly did its job, holding back spring runoff, keeping our basement dry while neighbors down the block pumped water out of theirs every April. I assumed, wrongly, that something useful and legal was something safe from Karen's attention. Richard Whitfield's name came up sometimes at neighborhood barbecues. Always vaguely, something in golf course management, someone would say, shrugging. Nobody connected it to anything. I didn't either. Closer at a man I'd met maybe twice, who mostly stayed inside while his wife ran the block. The first sign of trouble came in March. A certified letter with the HOA letterhead, citing unauthorized water containment structure altering natural drainage, and demanding removal within 30 days. No fine yet, just a warning. I laughed it off, assuming a quick phone call would clear up the confusion. I called the HOA office and got Karen herself, who informed me, without checking any file, that dams were not listed in the approved structures section of the covenants. I explained the county permit. She said the county wasn't the HOA, and the HOA's rules were separate and stricter than the county's. I asked to see which specific bylaw prohibited a permitted flood control structure. Karen said she'd have someone pull that for me, and never did. Every follow-up call ended the same way, vague citations, no documents, a tone that made clear the conversation was over whether I agreed or not. Mia thought I was overreacting when I got frustrated after each call. "It's probably just paperwork," she said, rocking 6-month-old Lily on her hip. I wanted to believe that too. I dealt with bureaucracies before. Usually a permit and a polite letter solve things. I didn't yet understand who I was dealing with. In April, the golf club announced its 25th annual charity cup, a fundraiser for a veterans housing nonprofit, expecting record attendance and press coverage. The event was to be held on the back nine, including the 8th fairway that ran alongside my property line and, unmistakably, alongside my dam. I didn't think much of the announcement at the time. Golf tournaments happened every year at Millbrook Ridge. I mowed my lawn, fixed a fence post, watched Lily take her first wobbling steps across the kitchen floor. Life moved forward while, unseen, something was quietly being decided about my land. What I didn't know then was that Richard Whitfield wasn't just vaguely in golf course management.
He held a minority ownership stake in Millbrook Ridge Golf Club through a holding company registered under his mother's maiden name, a detail buried in county business filings that wouldn't matter to me for months.
Karen, I'd later learn, sat on the club's beautification committee too, unpaid but influential, pushing for the 8th fairway to be widened and reshaped ahead of the anniversary tournament. My dam, and the little wetland pool it created, sat exactly where their expansion plans wanted: flat, dry, sellable green. The first rail shot came in May, an official violation notice, this time with a $400 fine attached, citing continued non-compliance on a structure I'd never agreed was non-compliant in the first place. I read it twice, certain there was some mistake. There wasn't. Herself. I drove to the HOA office that afternoon, permit folder under my arm, ready to settle this like an adult. Karen kept me waiting 25 minutes in a lobby chair before calling me in, sliding a printed covenant page across her desk without looking up from her computer screen. The page cited a clause about unauthorized alterations to natural waterways. I pointed out my dam wasn't a waterway. It was a permitted containment structure built specifically to manage one. Karen said the distinction was a technicality, and that the board had already voted to enforce removal. I asked who was on that board. She rattled off 3 names, 2 of whom I later found out hadn't been informed of any vote at all. When I asked for meeting minutes, she said they weren't finalized yet. When I asked for a timeline on when they would be, she said HOA business moved at its own pace. I left that meeting with a $400 fine, no documentation supporting it, and a distinct feeling that the rules were being written specifically for me, in real time, by one person. Mia suggested a lawyer. I told her it wasn't worth the cost yet. I still believed reason would win out. Word travels fast in a neighborhood of 40 houses. By the following week, 3 separate neighbors had quietly mentioned to me, in driveways and at the mailbox, that Karen had gone after someone before over something similarly petty. Nobody wanted to give details. Nobody wanted to be the next compliance spotlight. One neighbor, an older man named Walt who'd lived on Willow Creek since it was still farmland, told me flatly, "Just pay the fine and do whatever she wants. It's cheaper than fighting her." I asked why. He just shook his head and went back inside without another word. I paid the $400 under protest. A note attached explaining I disputed the violation but wouldn't let it accrue interest while I sorted it out. Karen cashed the check within 2 days and sent a new letter a week later, demanding the dam's removal regardless of the payment. That was the moment I understood the fine had never been about compliance. It was a toll, a first installment, proof that resistance cost money and got you nowhere. I called the county floodplain office to double-check my permit was still valid. It was on their end at all. The county employee I spoke to, a patient woman named Denise, seemed almost amused when I described the HOA's position. An HOA can have its own aesthetic rules, she said, but it can't override a state-permitted flood control structure. That's not how jurisdiction works. I wrote her words down verbatim. Armed with that, I sent Karen a formal letter citing Ohio Revised Code on Floodplain Management, explaining the HOA's covenant. Whatever it actually said, couldn't supersede a county permit tied to public safety. I expected the letter to end things. Instead, it seemed to make Karen angrier than the dam itself. Her reply arrived 4 days later. No longer signed simply HOA Board, but Karen Whitfield, President, Willow Creek Estates HOA, as if the title alone settled the matter. She wrote that outside agencies had no bearing on community standards, and that the board's decision was final, effective immediately. No further correspondence necessary. I forwarded everything to Mia's cousin, a paralegal, who read it over and said plainly, "This woman is bluffing, but bluffs can still bankrupt you in legal fees before a judge agrees you were right." That was the trap. Being correct wasn't the same as being able to afford proving it. Meanwhile, Karen's compliance spotlight in the June newsletter ran my address under the header, Ongoing Environmental Concern, implying, without stating outright, that my dam was somehow dangerous to the community. Neighbors who'd never spoken to me started giving me odd looks at the community pool. Reputation, I learned, was easy to weaponize. Lily got sick that same week. A bad fever that sent us to urgent care at 2 in the morning. I remember sitting in that waiting room, exhausted, thinking how absurd it was that alongside a scared new father's worries, I was also fighting a woman over a legally permitted pile of dirt and stone. When Lily recovered, I turned back to the fight with less patience than before. I filed a formal written appeal with the HOA board, demanding the actual meeting minutes, actual bylaw citations, actual proof any vote had occurred at all. Karen's response was 3 lines long. Appeal denied. Fine remains. Removal date set. The new removal date gave me 45 days. Circled on my calendar. That date sat 2 weeks before the Millbrook Ridge Charity Cup. I noticed the timing but didn't yet understand its significance. I thought it was coincidence. I was wrong. The timeline was ever really a coincidence at all. I decided to attend the next open HOA board meeting in person, hoping a room full of witnesses might force some accountability that private letters never had. The meeting was held in the clubhouse function room. Folding chairs arranged before a long table where Karen sat flanked by 2 board members who mostly stayed silent. I made my case calmly, laying the county permit on the table, reading Denise's explanation of jurisdiction aloud, asking directly why a legal, permitted flood structure was being treated as a violation. Karen listened with a thin smile, then said the board would take it under advisement, and moved to the next item. A board member named Priya, the treasurer, leaned toward the microphone and asked, hesitantly, whether the board had actually reviewed the county permit before issuing the fine. Karen cut her off, saying the matter was closed for discussion, and the meeting moved on before anyone could press further. Priya didn't speak again that night. After the meeting, Priya caught me in the parking lot, glancing back toward the clubhouse before speaking. "I've never seen the actual paperwork on this," she admitted quietly. "Karen just brings things to us already decided." I asked if she'd help me get real documentation. She hesitated, then nodded, just barely. Priya became, without either of us saying it out loud, a quiet ally inside the board. She couldn't openly oppose Karen without risking her own standing in the neighborhood, but she started forwarding me things. Meeting notices I'd never received, agenda drafts that mentioned my property before any vote had occurred. One email Priya forwarded showed Karen had emailed the board, weeks before my first violation notice, describing plans to clear obstruction along the 8th fairway boundary ahead of the anniversary tournament. My name wasn't in that email. My dam clearly was, though nobody had called it that at the time. I started keeping a folder, physical and digital, of everything, every letter, every email, every date. Mia thought I was becoming obsessive. Maybe I was. Uncertainty, her total lack of concern about being questioned, told me this wasn't going to end with one lost argument. It would escalate. In late June, a second neighbor finally opened up to me, an older woman named Frances whose fence Karen had forced removed 2 years earlier over a nearly identical dispute about property lines that later turned out, after Frances paid a surveyor herself, to be entirely on Frances's own land the whole time. She never apologized, Frances told me over coffee. The fence stayed down. I was too tired to fight for it back. I asked if she still had paperwork from that dispute. She did, kept in a shoebox, mostly out of spite, she admitted, in case she ever needed to prove she wasn't crazy. Frances's shoebox held something else. Too, an old HOA newsletter from 3 years back naming a different family, the Alvarados, in a compliance spotlight over a shed. The Alvarados had moved out within the year. Frances said quietly, "People don't usually just decide to leave a neighborhood they liked." I began to see a pattern forming. One dispute at a time, spread across years, each with the same shape, an obscure rule, a fine, an unyielding deadline, a resident too tired or too afraid to fight back. Karen wasn't reacting to violations. She was manufacturing reasons to reshape the neighborhood, piece by piece. Still, knowing a pattern existed and proving it were different things. None of the old disputes were documented well enough to build a real case. Frances's shoebox and Priya's forwarded emails were a start, not evidence. I needed something concrete, something that tied Karen's actions directly to a motive beyond simple control. That something arrived by accident. Mia, scrolling county business records for an unrelated reason, land taxes, stumbled across a filing for Whitfield Fairway Holdings LLC, registered 2 years earlier, listing Richard Whitfield as managing member. The company's stated business purpose: golf course facility management and expansion consulting. My stomach dropped reading it. I pulled the filing myself that night, hands slightly unsteady on the keyboard. Whitfield Fairway Holdings held a documented consulting contract with Millbrook Ridge Golf Club, specifically for course footprint optimization, ahead of anniversary renovations. My dam sat directly inside the mapped optimization zone shown in an attached site diagram. It wasn't proof of anything illegal. Not yet. Homeowners' spouses can consult for golf clubs. But it explained, suddenly and completely, why Karen cared so intensely about a small dam most residents had never even noticed. This was never about covenants or aesthetics. It was about clearing land her husband was paid to clear. I sat with that discovery for days, unsure what to do with it. Confronting Karen directly seemed pointless. She'd simply deny it or bury it further. I decided instead to keep gathering, quietly, patiently, the same way I'd design a structure layer by layer, until the foundation could hold real weight. Meanwhile, the HOA's pressure didn't slow down. A third notice arrived. This one threatening a lien against my property if the dam wasn't removed by the original deadline. Now 3 weeks away. Liens could complicate refinancing, complicate selling, complicate everything. Karen had found the one threat guaranteed to genuinely scare a young family. Mia and I argued that week. Not about the dam itself, but about how much of our savings I was willing to spend fighting it. She wasn't wrong to worry. Lawyers cost money we didn't have to spare with a toddler and a mortgage. I promised her I'd find another way before spending $1 on legal fees. I reached back out to Denise at the county floodplain office, this time asking a different question. Could a homeowner document, formally, that a structure served a public safety function beyond their own property, specifically protecting downstream areas, including neighboring land, from flood risk? She said yes, and offered to help me file it. That single conversation planted something in me I hadn't considered before. My dam didn't just protect my land. It slowed and redirected runoff that would otherwise flow, unimpeded, straight across the property line toward the low-lying 8th fairway of Millbrook Ridge Golf Club. Remove the dam, and that water had to go somewhere. I didn't act on that thought yet. It felt too much like a weapon I wasn't ready to use, and I still believed, however naively, that documentation and reason might resolve this before it came to anything drastic. I filed the county safety designation request and waited, the deadline ticking down around me. Karen, unaware of what I'd filed, escalated anyway. A fourth letter arrived, informing me the HOA board had voted, unanimously this time, to authorize hiring an outside contractor to remove the dam themselves if I hadn't complied by the deadline, with all costs billed directly to me, plus a administrative processing fee. Priya later confirmed, quietly, over a forwarded email chain, that the vote hadn't been unanimous at all. She had voted against it and been recorded as abstaining in the official minutes instead. When she raised the discrepancy, Karen told her the recording secretary must have misheard during the call. The contractor Karen hired, turned out, was a small demolition company that Richard Whitfield's holding company had also used twice before for course reshaping work. Another thread connecting husband and wife. Another quiet confirmation that this had never been about my dam violating anything except somebody else's business plans. I started documenting the contractor connection carefully. Screenshots, business registration cross-references, timestamps. Mia, watching me build the folder late one night after Lily was asleep, finally asked the question I'd been avoiding. What are you actually planning to do with all this? I didn't have an answer yet. What I did have, by early July, was a stack of evidence suggesting the fine was baseless. The vote was falsified, the contractor was conflicted, and the entire campaign traced back to a private business interest disguised as community enforcement. What I lacked was a moment where all of it would actually matter to someone. The Charity Cup tournament, now 3 weeks out, kept appearing in every neighborhood conversation. Banners going up along the clubhouse drive. A countdown graphic in the HOA newsletter. Sponsors' names printed on temporary signage along the very fairway that bordered my land. The whole community's attention was converging on one single day. I realized, almost reluctantly, that the timeline Karen had set for me, dam removal completed before the tournament, wasn't just about clearing land for renovation. It was about making sure the fairway looked pristine, expanded, camera-ready for the anniversary event, with press expected and Richard's consulting contract presumably paid out on completion. That meant the removal deadline wasn't flexible. Karen needed it done, one way or another, before that Saturday. Which meant, for the first time, I actually had leverage instead of just grievance. The question was no longer whether I could stop this. It was what I chose to do with the timing itself. I didn't share that realization with anyone yet. Not even Mia. Some plans need to sit quietly before they're ready to be spoken aloud. Instead, I focused on finishing my county safety filing, making sure every document was airtight, every date correct, every claim backed by something Karen couldn't simply talk her way around. Denise called mid-July to confirm the county had approved my request. The dam was now formally designated a flood mitigation structure protecting downstream properties, filed permanently into county records. It meant nothing could legally force its removal without a separate county review process. On paper, I had already won. Karen didn't know that yet. I chose not to tell her immediately. Instead, I let the HOA's deadline arrive, let their contractor letter stand, let Karen believe she still held every card. There was a version of this where I simply produced the county designation and ended things quietly. But quiet endings, I'd learned, taught Karen nothing at all. Frances, when I told her what I'd found about Whitfield Fairway Holdings, went very still for a moment before saying, "That's the missing piece. That's why none of us ever understood why she cared so much about things that shouldn't matter to anyone." She asked if I planned to make it public. I said I hadn't decided. Priya, separately, warned me that going public too early, before the tournament, might let Karen quietly cancel the removal order and cover her tracks, erasing the paper trail before anyone official ever saw it. "If you want this to actually stick," she said, "you need her to commit to something she can't undo." That conversation reshaped everything. I stopped thinking about how to stop the removal and started thinking about how to let it happen, on my own terms, at a moment Karen couldn't control or reverse. The dam, ironically, had become less valuable standing than it would be the instant it came down. I called Denise again, asking a hypothetical question this time. If a designated flood structure were removed by the property owner themselves, on their own authority, despite the county designation, was that legal? She confirmed it was. Homeowners could modify their own permitted structures. They simply assumed liability for downstream consequences. Liability. For days. If I removed the dam myself, I would be assuming legal responsibility for wherever that water went. Which meant I needed to know, precisely and provably, exactly how much water, moving exactly where, at exactly what volume, before I ever touched the structure myself. I spent a weekend with old rainfall data, elevation surveys from my original permit application, and a topographic map of the golf course obtained through public county GIS records. The math was unambiguous. Released suddenly, my dams held back water would flow directly downhill into the low basin of the 8th fairway within minutes. The 8th fairway, I confirmed through the same GIS records, sat nearly 4 feet lower than my property line, in a natural basin the golf course had built, directly over decades earlier without proper drainage correction. Something my dam had unintentionally been compensating for the entire time it stood there. In other words, my dam wasn't just protecting my yard. It had been quietly protecting the golf course itself from its own uncorrected drainage flaw for 2 years, absorbing runoff that would otherwise pool exactly where Karen wanted a pristine, dry fairway for her husband's tournament and camera cruise. I sat with that irony a long time. The structure Karen wanted destroyed was the very thing keeping her husband's business interest from flooding. Remove it carelessly, at the wrong moment, and the golf course would drown in the exact water it had spent years relying on my land to quietly absorb. For a stretch of about 2 weeks, things went unusually quiet. No new letters, no new fines, no compliance spotlight mentioning my address. I almost let myself believe Karen had backed off. Maybe realized the county designation made further pressure pointless. Mia relaxed a little too, cautiously, watching Lily learn to run across the yard. Priya explained the silence differently. Karen, she said, was consumed with tournament logistics, sponsor calls, catering vendors, press coordination, leaving little bandwidth for anything else. It wasn't a retreat. It was a pause. The kind that happens right before someone redirects all their focus toward one final, decisive push. I used the quiet to prepare rather than relax. I met with a small excavation crew I trusted, off the record, discussing what it would actually take to breach the dam cleanly, quickly, and safely if the moment ever called for it. They quoted me a price. I didn't hire them yet. I also reached out, carefully and anonymously at first, to a reporter at the local paper who'd covered zoning disputes before, asking hypothetical questions about how HOA overreach stories were typically sourced and verified. She seemed interested but non-committal without documents. I told her I might have documents soon. She gave me her direct line. Francis, during this lull, told me something new. The Alvarado family, the ones whose shed dispute had appeared in an old newsletter, hadn't just moved away quietly. They'd sold their house at a loss, under pressure, after Karen allegedly told other neighbors, informally, that the Alvarados were difficult and bad for property values. That detail mattered more than it seemed at first. It suggested Karen's tactics extended beyond fines and letters into deliberate reputational damage, whispered just enough to make a family's life quietly unbearable until leaving felt like the only option. I began to understand the actual scale of what one person had built. I spent an evening writing out a timeline, start to finish, connecting every piece, the original dam permit, the fines, the fabricated vote, the demolition contractor tied to Whitfield Fairway Holdings, the tournament date, the fairway's drainage flaw, the county safety designation. laid out together. The picture was no longer ambiguous at all. Mia read the timeline one night after Lily was asleep. Quiet for a long time afterward. "This isn't really about a dam anymore, is it?" she finally said. I told her the truth. It hadn't been about the dam for a while. It was about whether one person got to quietly ruin people's lives unchecked. She asked what I intended to do. I told her my plan, still forming, involved letting Karen's own deadline and her own tournament collide. Publicly, undeniably, in a way that couldn't be quietly buried in meeting minutes afterward. Mia was quiet, then said only, "Make sure you can prove every piece of it." That became my standard for the following 2 weeks. Every claim needed backup. Every date needed a paper trail. I wasn't interested in rumor or satisfaction alone. If this was going to end publicly, it needed to end with something a lawyer, a reporter, or a judge could verify within minutes, not months. I quietly filed a formal complaint with the county recorder's office regarding the falsified board vote Priya had described, using her forwarded emails as supporting documentation, careful to keep her name anonymized within the filing itself, protecting her position while still creating an official record of the discrepancy for later use. Karen, unaware of any of this, resurfaced publicly with a burst of tournament promotion. A glossy flyer mailed to every household announcing the 25th Charity Cup, mentioning proudly that the newly expanded 8th Fairway would debut that Saturday, thanks to generous community cooperation. My address wasn't named. Everyone who mattered knew anyway. The flyer's phrase, "generous community cooperation," landed like a slap. There had been no cooperation. There had been fines, threats, a fabricated vote, and a family quietly deciding, under duress, they had no realistic way to keep fighting. I read that flyer 3 times before finally deciding the quiet phase was over. The 5th and final HOA letter arrived the following Monday, stating plainly that if the dam wasn't removed by end of day Friday, 3 days before the tournament, the hired contractor would proceed regardless, with full costs and a newly added, expedited removal surcharge, billed directly against my property as a lien. I called the contractor's office myself, posing as a prospective client, and confirmed what Priya had already told me. They were booked for Friday morning specifically, for a residential water feature removal at an address that matched mine, prepaid, according to the receptionist, by the HOA management account directly. That single call gave me something crucial, a confirmed date and time for their planned arrival. If Karen's people were coming Friday morning, I had one final window, Thursday, to act on my own terms before anyone else touched my property or my structure at all. I called Denise one more time, confirming again that I retained full legal authority to modify my own permitted structure myself, so long as I documented it properly and assumed responsibility for downstream flow. She reminded me, almost as an aside, that county safety designations couldn't be overridden by private contractors regardless. That meant if the HOA's crew arrived Friday to find the dam already breached by me, legally, on my own authority, there would be nothing left for them to remove, no bill to issue, no lien to file, and, more importantly, no way for Karen to claim credit for clearing the fairway herself. I called the excavation crew I'd consulted earlier and asked for their earliest available slot. They could come Thursday afternoon. I asked, deliberately, for the earliest hour that would put the breach at a specific time of day. One that mattered far more than they realized when I made the request. The Charity Cup's opening ceremony, according to the flyer, began Thursday evening with a VIP preview round for major sponsors and local press, walking the newly reshaped 8th fairway before Saturday's main event. Karen's own promotional materials had told me, without meaning to, exactly when the most people would be watching that ground. I hadn't set out, months earlier, to time anything around a golf tournament. But every piece, the fine, the fabricated vote, the drainage flaw, the tournament schedule, the contractor's confirmed date, had assembled itself into a single narrow window where truth and consequence could finally meet in front of witnesses who couldn't be ignored. Mia, when I explained the full plan, sat quietly for a long moment before asking the only question that mattered. Are you sure the water actually goes where you think it goes? I told her about the topographic survey, the elevation data, the drainage basin, the 2 years of quiet, unacknowledged flood protection. I'm sure, I told her. I'm an engineer. Everything. She nodded slowly, then added something I hadn't expected. Then don't just breach it quietly. Make sure someone besides us sees exactly what comes out of that ground, and exactly why it was ever there. That advice reshaped my final plan. This couldn't just be an act. Water released, fairway flooded, satisfaction taken privately. It needed witnesses, documentation, someone outside the neighborhood who could describe what happened without Karen controlling the narrative afterward the way she'd controlled every newsletter and every meeting for 11 years. I called the reporter, Sarah Kessler, and told her, honestly, that I had documents suggesting HOA misconduct tied to undisclosed financial interests, and that something relevant to that story might happen publicly at a golf tournament that Thursday evening. She asked, carefully, whether I was planning anything illegal. I told her no. Legal. Sarah agreed to attend the VIP preview round herself, credentialed as press covering the anniversary tournament, a plausible cover that raised no suspicion with anyone at the club. I sent her, ahead of time, digital copies of the permit, the county designation, the falsified vote emails, and the Whitfield Fairway Holdings filing. I also reached out, finally, to a real estate attorney, not to file anything yet, but to walk through exactly what I intended to do and confirm, in writing, that removing my own permitted structure on my own authority carried no legal exposure beyond standard downstream liability I'd already documented and accounted for. The attorney, a calm woman named Renata, reviewed everything for an hour before saying simply, "You're not doing anything wrong here. You're doing something inconvenient for someone who's been counting on you not knowing your own rights. Those are very different things." I felt, for the first time in months, steady. Thursday morning arrived overcast, humid, the kind of pre-storm air that made the whole neighborhood feel like it was holding its breath. I walked the property line one last time, checking elevation stakes, confirming flow direction, making sure everything matched the survey I'd handed Renata and Sarah both, independently, days before. The excavation crew arrived at 2 in the afternoon, exactly as scheduled, 3 hours before the VIP preview round was set to begin on the 8th fairway. I met them at the gate, permit copies in hand, explaining precisely what I needed, controlled breach, not a demolition. Releasing water gradually but completely. Their foreman, a quiet man named Dale, reviewed my survey data without much comment, nodded, and said his crew could have the breach open within 40 minutes once they started. I told him to hold until my signal. I wanted the timing exact. Not a minute early, not a minute late. At 3:15, I called Sarah to confirm she was in position near the 8th fairway with press credentials. Camera ready, watching Karen and Richard Whitfield walk the newly reshaped ground with a small cluster of sponsors and club officials. She confirmed everything looked exactly as expected. Freshly graded. Dry. Camera perfect. 3:40. I called Priya, who'd asked to know when it happened. Not to participate, but simply to witness something honest occur after years of watching dishonest things happen unchallenged. She thanked me quietly, said only, "Be careful," and stayed on the line while I walked back toward the dam itself. I stood at the edge of the water my dam had held back for 2 years, clipboard in hand, time-stamped photographs already taken, permit paperwork sealed in a folder inside the house. Mia stood beside me, Lily on her hip, watching the same water that had once flooded our porch about to be released on purpose. At exactly 4 o'clock, with the VIP preview round in full swing according to Sarah's texted updates, I gave Dale the signal. His crew began the controlled breach precisely as planned, opening a channel that let 2 years of held-back water begin moving, steadily and unstoppably, down the natural slope toward the golf course. The first sign of trouble on the golf course side, Sarah told me later, wasn't dramatic. Just a darkening patch of grass near the 8th green, spreading faster than anyone expected, as if the ground itself had suddenly decided to become a shallow lake exactly where sponsors' shoes were meant to stay dry. Within 15 minutes, according to Sarah's real-time account, water was visibly pooling across the newly reshaped fairway, rising fast enough that club staff began ushering VIP guests back toward the clubhouse, confusion spreading through the group faster than the water itself. Nobody yet understanding where it was coming from or why. Richard Whitfield, Sarah reported, was the first to react with real alarm, immediately pulling out his phone, walking briskly toward the tree line separating the course from my property. Exactly toward the source he apparently recognized far faster than anyone else standing there that afternoon, sponsors and officials included. Karen, meanwhile, stood frozen for a moment, according to Sarah, staring at the rising water with an expression Sarah described as somewhere between disbelief and dawning recognition, before she too began moving quickly toward the property line, heels sinking slightly into ground that had been solid an hour before. By the time Karen and Richard reached the tree line, the breach was fully open, water moving in a steady, controlled sheet exactly as engineered, spreading across the low basin of the fairway with the kind of unstoppable calm that no amount of shouting or panic could reverse or redirect at that point. I stood on my side of the property line, permit folder in hand, watching Karen's face as she registered, fully, what was happening. She didn't say anything at first. She simply stared at the water, then at me, then at the folder I was holding, as if trying to calculate what I actually knew. "You can't do this," she finally said, voice tight, carrying across the shrinking gap of dry ground between us. I held up the folder. "Nation," I said, confirming this structure protects downstream property, including yours, from exactly what's happening right now. I have every legal right to modify my own land. Richard, standing beside her, said nothing at all, his eyes fixed on the water, then briefly on me, then on his phone screen, already typing something urgently, presumably to whoever managed the golf course's insurance or emergency drainage contacts, people who were about to have a very difficult evening ahead of them. Sarah approached at that moment, press badge visible, camera raised, asking Karen directly, on record, whether she was aware her husband held a documented financial interest in golf course renovations that directly overlapped with HOA enforcement actions against a homeowner's permitted flood structure. Karen's expression shifted from panic to something colder, more calculating. "I have no comment," Karen said, turning away sharply, pulling Richard by the arm back toward the clubhouse, leaving sponsors and club officials standing in ankle-deep water, murmuring among themselves, several already pulling out their own phones to photograph the flooding for reasons that had nothing to do with charity promotion. Within the hour, the VIP preview round was formally called off. Sponsors ushered inside with damp shoes and confused expressions. The eighth fairway transformed into a shallow, spreading pool exactly where a golf ball was supposed to land cleanly the next morning for the tournament's much-promoted anniversary photo opportunity. Sarah's article, filed that same night, ran the following morning under the headline, "HOA President's Husband Held Undisclosed Stake in Golf Course Amid Flood Control Dispute," laying out the timeline plainly: the permit, the fine, the falsified vote, the Whitfield Fairway Holdings filing, and the precisely timed, entirely legal breach. The article spread through the neighborhood faster than any newsletter Karen had ever written, forwarded in group chats, printed and left in mailboxes, discussed at the community pool by people who, weeks earlier, had given me strange looks over rumors of an environmental concern attached to my own address. Priya, freed by the public record finally matching what she'd witnessed privately for years, submitted a formal statement to the county recorder's office confirming the falsified board vote, attaching her original emails. No longer worried about protecting a board position within an organization she'd quietly lost faith in months earlier, Frances brought her old shoebox of documents to a hastily called emergency HOA meeting the following week, laying out, alongside my own timeline, a pattern stretching back years: fence disputes, shed disputes, families who'd quietly left the neighborhood after enduring exactly the kind of pressure I'd only recently begun to understand fully. The emergency meeting, held in the same clubhouse function room, drew a crowd larger than any HOA gathering in the community's history. Folding chairs filled twice over, people standing along the back wall, all of them there for the same reason, finally watching one person's authority collapse under its own documentation. Karen attempted to open the meeting normally, gaveling for order, but was interrupted almost immediately by a resident demanding to know whether the fine issued against me had ever actually been approved by a real board vote. Priya, present and no longer silent, confirmed publicly that it had not. The room's mood shifted visibly at that confirmation, murmurs rising into open questions, one after another, about past disputes, past fines, past compliance spotlights, each one now viewed through a lens that made Karen's 11 years of quiet authority look considerably less like enforcement and considerably more like something else entirely. Karen tried, briefly, to redirect the meeting toward procedural matters, insisting questions be submitted in writing for future review. A resident near the back, someone I didn't recognize, stood and asked loudly whether future review meant the same indefinite delay Frances had experienced regarding her fence 3 years earlier. The county's own involvement became public knowledge that same week, when Denise's office confirmed, in response to a resident's formal inquiry, that my dam's safety designation had been on file for over a month before the HOA's final removal deadline, meaning Karen had continued pressuring me despite knowing, or willfully not checking, its legal status. Local news picked up the story 2 days after Sarah's initial article. A television crew filming the still-drying 8th fairway, interviewing sponsors who described, on camera, their surprise and mild embarrassment at having posed for anniversary photos ankle-deep in water nobody had explained to them at the time it happened. Millbrook Ridge Golf Club's general manager issued a statement distancing the club from any individual homeowner association's internal disputes, while quietly confirming,
when pressed by Sarah, that Richard Whitfield's consulting contract for course expansion had been placed under internal review pending the outcome of the unfolding controversy.
The Charity Cup itself proceeded that Saturday, delayed by 2 hours while grounds crews worked to dry and reset the 8th fairway. The veterans' nonprofit still receiving its funding, though several sponsors quietly withdrew their branded signage from that particular hole, unwilling to have their names associated with the unfolding story. Karen attempted, in the days following, a final public defense, a lengthy letter mailed to every household insisting the flooding was reckless and dangerous, omitting entirely the county safety designation, the falsified vote, or her husband's financial interest, a letter that convinced almost no one who'd already read Sarah's article. Renata, my attorney, advised me formally at this point to consider filing a countersuit against the HOA for the improperly assessed fine, the falsified vote, and the attempted unauthorized lien, arguing the pattern of documented misconduct, combined with Frances's and the Alvarado's prior experiences, made a strong civil case. I hesitated briefly, uncertain whether pursuing legal action would drag this out longer than I wanted. But Frances, when I mentioned it, said quietly, someone has to be the one who finally makes it cost her something real. It might as well be the person who already proved everything anyway. We filed within 2 weeks a civil complaint against the HOA board, naming Karen specifically, citing the falsified vote, the improperly issued fine, the attempted lien, and requesting, alongside damages, a formal audit of the association's finances covering her entire 11-year tenure as president, something no resident had ever successfully demanded before. The lawsuit's filing became its own news cycle locally, prompting several other residents, emboldened by the public record now firmly established, to come forward with their own decade-old grievances, complaints they'd never filed because, individually, none of them had ever felt like enough to challenge someone as entrenched as Karen. An informal group chat formed among affected residents, sharing old newsletters, old fine notices, old letters, slowly assembling a shared timeline that echoed my own. Each entry a small confirmation that the pattern Frances and I had suspected was real, was documented, and was, finally, being taken seriously by people outside the neighborhood. Karen, facing mounting pressure, requested and received a temporary leave of absence from her HOA president role, pending review. A phrase the board used carefully, unwilling yet to state outright what most residents already understood, that her decade of unchecked authority had reached its natural, overdue conclusion. The temporary leave didn't slow Karen down. Within days, residents reported her still showing up uninvited at HOA committee meetings, still emailing vendors under her old title, still instructing the same demolition contractor, the one tied to Whitfield Fairway Holdings, to hold pricing for future projects she apparently still believed were hers to authorize. Priya, now effectively running board communications in Karen's absence, discovered Karen had quietly transferred several HOA vendor contracts, landscaping, snow removal, security patrol, to companies with loose but traceable connections to Richard's business network. Arrangements that had never been competitively bid or disclosed to the board as required. That discovery expanded the scope of everything. This wasn't only about my dam or Francis's fence or the Alvarado's shed. It suggested years of HOA dues, community money paid by every household in Willow Creek, had been quietly funneled toward vendors chosen for personal benefit rather than genuine community value. Renata folded this new evidence into an amended complaint, requesting the financial audit be expedited given the apparent scale of potential misconduct. No longer just about one falsified vote, but about a pattern of self-dealing that, if confirmed, could expose Karen to consequences well beyond a civil dispute over a dam. Karen's response to the amended complaint was, by every account, dramatically different from her earlier composed denials. Neighbors reported raised voices from inside her house during a visit from two board members attempting to formally request her resignation. Richard's SUV, usually parked in the driveway overnight, was gone for several days. Francis, watching all of this unfold with something between satisfaction and genuine sadness, told me one afternoon that she almost felt sorry for how completely it was collapsing, before adding immediately, without much hesitation, almost. Then I remember what she took from the Alvarados, and I stopped feeling sorry at all. Karen attempted a counter-narrative through a hastily arranged interview with a different, smaller local outlet, framing herself as a dedicated volunteer being unfairly targeted by a coordinated smear campaign. The interview backfired almost immediately when the reporter, following up independently, confirmed the falsified vote and vendor connections were already verified matters of record. The financial audit, once formally authorized by the board under mounting resident pressure, uncovered discrepancies stretching back nearly 6 years. Invoices marked paid to vendors, with no corresponding service records. HOA reserve funds drawn down for landscaping improvements that neighbors, walking their own streets, confirmed had simply never been performed. One particularly damning discovery involved a drainage improvement fund Karen had established 3 years earlier, collecting a special assessment from every household specifically, citing flood mitigation needs, money that, according to the audit, had never funded a single actual drainage project anywhere within the Willow Creek Estate's boundaries. Residents who'd paid that special assessment, myself included, felt a particular kind of anger reading that line in the audit report. Karen had fined me for owning an actual, permitted, functioning flood mitigation structure while apparently pocketing community funds collected under the explicit promise of building exactly what she'd fought so hard to destroy. Renata, upon seeing the audit's drainage fund findings, said it transformed the civil case considerably, suggesting potential grounds for a fraud referral to the county prosecutor's office, well beyond the scope of a typical HOA dispute, moving this now firmly into territory with real, lasting legal consequences for Karen personally. Karen's leave of absence became, within days of the audit's release, an outright forced removal, the board voting unanimously, this time verifiably and on the record, to strip her of the HOA presidency entirely, citing the documented financial discrepancies and the falsified vote as grounds under the association's own bylaws. The vote to remove her took place at another packed clubhouse meeting. Karen notably absent this time, having sent a brief written statement read aloud by a board member, insisting the audit was incomplete and politically motivated. A statement met largely with silence and a few audible, unimpressed exhales from the crowd. Priya was elected, unanimously, as interim HOA president that same evening, immediately announcing plans for a full external financial review, a revised transparent fine and violation appeals process, and a formal apology to residents, including me and Francis specifically, for years of enforcement actions never properly reviewed by the board. I attended that meeting quietly, near the back, not seeking recognition, though several neighbors I'd barely spoken to before approached afterward, thanking me for pushing something into daylight they'd all quietly suspected but never had the documentation, or the courage, to confront directly on their own for so many years. Word reached me a few days later, through Sarah, that Millbrook Ridge Golf Club had formally terminated Richard Whitfield's consulting contract, citing the ongoing controversy and reputational risk to the club's Veterans Charity Partnership, a partnership the club's leadership was apparently unwilling to let collapse over one family's undisclosed business dealings. Richard, according to neighbors who still occasionally saw him, appeared increasingly rarely at the house, the black SUV gone for stretches at a time, rumors circulating, unconfirmed but persistent, that the marriage itself was under strain from the financial and reputational fallout neither of them had anticipated when this began. I tried not to take satisfaction in that particular rumor, reminding myself, and occasionally Mia, that the goal had never been to destroy anyone's marriage or personal life, only to stop a pattern of abuse of authority that had genuinely harmed real families for years before I'd ever bought this land. Mia reminded me, gently, that consequences weren't the same as cruelty, that Karen's own choices, not my dam, not my breach, not Sarah's article, had built the foundation everything eventually collapsed onto. I found that framing useful, something to hold onto during the moments the situation still felt uncomfortably personal. The county prosecutor's office, following Renata's fraud referral, opened a formal investigation into the drainage fund discrepancies, requesting the full audit and supporting documentation from the HOA board. Priya cooperated fully, providing everything requested within days. Eager to demonstrate the association's new leadership had nothing left to hide from anyone. Karen retained her own attorney at this point. A sign, Renata noted, that she finally understood the seriousness of what was unfolding, no longer treating this as a manageable neighborhood dispute but as something with real potential criminal exposure attached to years of decisions she'd apparently believed no one would ever examine closely. My civil lawsuit, still proceeding separately from the criminal investigation, reached a mediation stage that autumn. Karen's attorney proposing a settlement covering my legal fees, the original fine reimbursed with interest, and a formal written retraction of every compliance spotlight and violation notice ever issued against my property specifically. I accepted the settlement's financial terms but insisted, through Renata, on an additional condition: a public correction in the HOA newsletter, the same publication Karen had used for years to shame residents by name, explicitly stating my dam had always been legally permitted and never in violation of any valid, properly enacted covenant. Karen's attorney resisted that condition initially, before ultimately agreeing, likely recognizing that continued resistance risked prolonging a case that was, by every measure, already thoroughly documented and increasingly public. The retraction ran in Priya's first newsletter issue as interim president, printed plainly, without softening language or excuses. Frances filed her own claim shortly after mine settled, citing the same pattern of documented misconduct, seeking reimbursement for the surveyor she'd hired years earlier to prove her fence had never actually violated any property line, expenses she'd quietly absorbed alone at the time, believing no one would ever back her up. The Alvarado family, tracked down through old neighborhood contacts, was contacted by Renata's office as well, given the opportunity to file their own claim regarding the pressure that had led to their below-market sale years earlier. They agreed, cautiously, still somewhat disbelieving that anyone was finally taking their old complaint seriously. Watching these separate claims accumulate, each one independently documented, each one echoing the same shape of manufactured violation followed by relentless pressure, made clear something I'd only suspected earlier. Karen's tenure hadn't been an occasional overreach. It had been a sustained pattern, executed confidently precisely because no one had ever compiled it before. The criminal investigation into the drainage fund concluded that winter, the county prosecutor's office announcing formal charges against Karen for misuse of association funds, a felony given the total amount involved across multiple years. A charge that made local news again, this time with Karen's name in the headline directly. Karen's arraignment drew a modest crowd of onlookers. Some residents, some simply curious locals who'd followed the story through Sarah's ongoing coverage. She appeared composed, according to those present, entering a not guilty plea, her attorney signaling intent to fight the charges rather than pursue any early plea agreement. I didn't attend the arraignment myself, choosing instead to spend that afternoon with Mia and Lily at the county park. A deliberate decision to keep some distance between my own life and the legal machinery now grinding forward independently, propelled by evidence rather than requiring my continued personal involvement at every step. The HOA, under Priya's continued leadership, used the winter months to overhaul its governance structure entirely, instituting recorded votes, published meeting minutes within 72 hours, an independent appeals process for violation notices, and a hard rule prohibiting board members from awarding contracts to any business tied to their own family. Residents, myself included, were invited to submit feedback on the new bylaws before a final community vote. A level of transparency Willow Creek Estates had simply never experienced under Karen's 11 years of leadership, something several longtime homeowners described, almost wistfully, as feeling like a genuinely different neighborhood entirely. I attended that final bylaws vote, watching the new rules pass nearly unanimously, a formal, documented end to the kind of unchecked authority that had let one person quietly reshape a community for over a decade based on nothing more than personal preference dressed up as procedural necessity and community standards. Mia, standing beside me at that meeting, squeezed my hand at one point and said quietly, "This is what it was actually for, wasn't it? Not just the dam." She was right. The dam had been the flashpoint, the specific injustice I could document and prove. But the real fight had always been larger. Spring arrived, and with it, the anniversary of the flooding I'd caused the previous summer. Though this time the 8th fairway drained properly. A corrected drainage system finally installed by the golf club's new, independently contracted engineering firm. One with no connection whatsoever to Whitfield Fairway Holdings or its dissolved consulting arrangement. I received, unexpectedly, a call from the club's new general manager, asking whether I'd be willing to consult, informally and compensated, on the corrected drainage design given my professional background and my obvious familiarity with the specific hydrology of that stretch of land bordering my own property line. I agreed, finding something quietly satisfying in the arrangement, the same engineering knowledge that had once been dismissed as an inconvenient obstruction now being formally, professionally valued by the very institution that had spent months trying to force its removal without ever once asking whether it might actually be protecting them too. Karen's criminal trial began that spring, stretching across several weeks of testimony. Financial experts walking the jury through years of discrepancies. Priya testifying about the falsified vote. Frances testifying about her fence. Several other residents describing patterns of pressure and intimidation stretching back further than even I had fully documented. I testified as well, laying out the dam's timeline plainly. The permit, the fine, the fabricated vote, the county safety designation, the tournament timing, careful to stick only to documented fact, resisting any temptation toward theatrical emphasis, letting the paper trail itself carry whatever weight it needed to carry in that courtroom. Richard Whitfield did not testify, having reached, weeks earlier, a separate civil settlement with the golf club over the terminated consulting contract, quietly relocating out of state according to neighborhood rumor, the marriage apparently having ended sometime over the winter, though neither he nor Karen ever confirmed it publicly. The jury deliberated for just under 2 days before returning a guilty verdict on the primary counts of misuse of association funds. Karen sitting motionless as the verdict was read, according to Sarah, who covered the trial's conclusion for what had become an ongoing local investigative series on HOA governance failures. Sentencing came several weeks later. Restitution ordered to the HOA and, by extension, its residents, alongside a period of probation and a court order permanently, barring Karen from holding any position of financial authority within a homeowners association anywhere in the state for a fixed number of years following the conviction. Karen left the courthouse that day without speaking to reporters, without the composed confidence that had once filled clubhouse meeting rooms and certified letters alike. Just a quiet exit through a side door, the kind of ending that felt, to those of us who'd lived through her decade of authority, entirely fitting. I didn't feel triumphant watching the coverage that evening. Not exactly. It felt more like exhaling after holding a breath for far too long. A tension I hadn't fully realized I'd been carrying since that first certified letter arrived. Finally, definitively, released. The same way the water had finally released from behind my dam. Mia asked. That night, whether I regretted any part of it. The fight, the cost, the months of stress layered on top of a new baby and a new house. I told her the only thing I regretted was not documenting things sooner, not trusting my own instincts the very first time something felt wrong. Frances stopped by a few weeks later with a bottle of wine and, finally, an offer to throw her old shoebox away, joking that she no longer needed proof she wasn't crazy since the entire county now had the same proof, filed permanently and publicly, in official court records instead. The Alvarado family, having settled their own claim quietly that spring, sent a short, handwritten note through Renata's office, thanking the residents who'd finally spoken up on their behalf, mentioning they'd since bought a small house elsewhere, smaller than Willow Creek, but, they wrote, somewhere nobody watches your mailbox for a living. Priya, formally elected HOA president that summer in an actual contested election. The first Willow Creek estates had held in over a decade, ran unopposed by anyone remotely, resembling Karen's old approach, campaigning openly on transparency and accountability, values that had, remarkably, once seemed radical within this particular neighborhood. I stayed involved at a modest level, attending meetings occasionally, offering engineering input when drainage or infrastructure questions arose, careful not to let myself become the new version of anyone dominating community decisions unilaterally, mindful of exactly how that pattern had started small before growing into something much larger and harder to stop. Lily turned 2 that summer, taking her increasingly confident steps across a backyard that included, still, the small pond and dam that had started this entire ordeal, rebuilt slightly stronger by the excavation crew after the breach, now formally recognized, documented, and protected under both county and, finally, HOA record as well. I sometimes stood at the edge of that water in the evenings, watching it hold steady the way it was designed to, thinking about how close I'd come to simply paying fine after fine, quietly complying, becoming one more entry in a shoebox some other frustrated resident might have kept for themselves someday. Sarah's continuing coverage of HOA governance issues expanded well beyond Willow Creek Estates after the story's initial publication, prompted several other local associations to voluntarily review their own bylaws and financial practices, residents elsewhere citing our neighborhood's ordeal directly as the reason they'd finally started asking their own uncomfortable questions. Renata told me, closing out the final paperwork on my settlement that autumn, that cases like mine rarely unfolded so cleanly, most residents lacking either the documentation instinct, the professional background, or simply the stamina to see something like this through from a $400 fine to a felony conviction and full bylaw overhaul. I told her honestly that stamina had nearly run out more than once. That without Priya's quiet cooperation, Frances's shoebox, Sarah's willingness to show up with a camera at exactly the right moment, this could just as easily have ended the way Karen clearly expected it to, with me paying, complying, and leaving quietly. That thought stayed with me longer than any single dramatic moment from the whole ordeal. The recognition that justice here hadn't come from one clean, decisive act alone, but from a slow accumulation of small, brave choices made by several different people who'd each decided, individually, enough was finally enough. The following spring, Willow Creek Estates held its annual community picnic, The first in years actually organized collaboratively rather than dictated top-down by newsletter. Families setting up blankets near the pond. Kids running past the dam without a second thought. The structure now just another unremarkable feature of an ordinary neighborhood. Priya gave a short speech that afternoon, thanking residents for their continued engagement, mentioning briefly, without dwelling, that the association's reserve fund had been fully restored through Karen's court-ordered restitution. Every dollar accounted for publicly now, available for any resident to review whenever they wanted. No exceptions. No gatekeeping. I watched Lily chase a dog across the grass near the water's edge. Mia beside me, the late afternoon sun catching the surface of the pond in a way that felt, for the first time in a long while, simply pleasant. No longer a battleground, no longer a symbol, just water doing exactly what it was built to do. Someone asked me that day, casually, whether I still checked the county floodplain records out of habit. I laughed and admitted I did. Occasionally, not from anxiety anymore but something closer to quiet pride. A reminder that the paperwork I'd once dismissed as tedious bureaucracy had ultimately been the thing that saved everything. Frances joined us on the blanket eventually, mentioning she'd started attending HOA meetings regularly now. Not out of obligation but genuine interest. Curious what an association actually run for residents, rather than around one person's preferences, could accomplish when nobody was afraid to ask a simple, direct question anymore. I thought, watching the picnic unfold around us, about how differently this all could have ended if I'd simply paid that first $400 fine and walked away, the way Walt had quietly advised, the way so many others clearly had before me, disappearing one by one into old newsletters nobody kept. Instead, a dam meant to hold back a creek had ended up holding back something far larger. An entrenched pattern of quiet abuse that had shaped this neighborhood for over a decade. Released all at once. Deliberately. Precisely. At the one moment it could no longer be quietly explained away by anyone. Karen's name came up rarely now. Mostly in passing. Mostly among longtime residents comparing notes on how strange it felt that the woman who'd once controlled every driveway, color and mailbox post now lived, according to the last anyone heard, quietly and anonymously somewhere outside the county. Restitution payments arriving on schedule. I never spoke to her again after the trial concluded. No final confrontation. No dramatic last word exchanged across a property line. The paperwork. The courtroom. The newsletter retraction. The removed presidency. All of it had already said everything that needed saying, more thoroughly and more permanently than any conversation ever could have. Mia and I talked, that evening after the picnic, about eventually adding a small dock to the pond. Something for Lily to fish off of when she got older. Quiet, ordinary plan for a quiet, ordinary piece of land that had, against every expectation, become the center of something much bigger than either of us ever intended. I still keep the original folder, the county permit, the certified letters, the falsified vote emails, the Whitfield Fairway Holdings filing, organized carefully in a fireproof box in the closet, not out of lingering anxiety but as a reminder, for myself and eventually for Lily, of what documentation and patience can accomplish. Renata told me once that most people who'd lived through something like this wanted to move on quickly. Forget the details. Avoid revisiting the stress. I found the opposite true for myself, the details matching more with distance. Each document a small proof that persistence, applied carefully, had genuinely mattered in the end. Priya, still president 2 years later, occasionally sends me drafts of new bylaw proposals for engineering input, a working relationship built entirely on the trust established during those quiet months. She'd forwarded me emails at real professional risk to herself, never once asking for recognition beyond simply doing what felt right. Sarah's series on HOA governance eventually won a regional journalism award, crediting Willow Creek Estates as the story that launched a broader investigation into similar patterns across the county. Several other associations facing their own overdue audits and leadership changes in the years following our neighborhood's very public reckoning. Frances, now genuinely active on the HOA's newly formed Transparency Committee, jokes sometimes that she's become exactly the kind of engaged resident Karen always claimed to want. Minus the fear, minus the fines, minus the compliance spotlights. Simply a neighbor who shows up, asks questions, and expects honest answers in return. I think, sometimes, about Walt's advice that first difficult spring, just pay the fine, is cheaper than fighting her. Advice given not out of cowardice but out of genuine, hard-earned experience with exactly how expensive fighting Karen alone had always been for anyone who tried it before documentation made the difference. What made this fight different, ultimately, wasn't courage alone. It was the accidental convergence of a permitted structure, a hidden financial motive, a tournament deadline, and enough patient documentation to turn one homeowner's frustration into something undeniable. Something that couldn't simply be filed away in a drawer or quietly forgotten. The dam itself required only minor annual maintenance now, a task I handled myself each spring, clearing debris, checking the spillway, work that felt, these days, almost meditative, a small physical ritual connecting me back to the moment 2 years of quiet water had finally been released exactly where it needed to go. Lily, old enough now to ask occasional questions about the flood, gets a simplified version of the story, something about a dam protecting our house and a golf course learning an important lesson about listening to engineers, a version that will grow more complete as she does, one honest layer at a time. Mia and I don't dwell on the ordeal much anymore, not because it stopped mattering, but because it resolved, completely and documentably, in a way few disputes like it ever managed to. The water still flows exactly where it's supposed to. The neighborhood still functions. Now, on rules everyone can actually see. It was the following August, over a year after the flooding, when the final consequence of everything arrived, quiet and unexpected, in the form of a letter, not from an HOA this time, but from the state licensing board, regarding a professional engineering complaint someone had filed against the original golf course drainage design. The complaint, filed by the club's new engineering firm during their corrective drainage work, alleged the original 8th fairway grading, installed decades earlier, had been improperly certified, missing critical drainage calculations that any competent review should have caught. A certification, the letter noted, signed off on by a firm connected distantly to Richard Whitfield's family. I hadn't known that detail before, that the flawed drainage basin itself, the one my dam had unknowingly protected for 2 years, traced back to Richard's own extended family decades earlier, a design flaw quietly inherited and then, ironically, protected from scrutiny for years by the very structure Karen had fought so hard to remove. It meant the golf course's vulnerability to flooding hadn't started with me at all. It had been built into the ground itself before I ever bought my land. A slow-motion problem waiting decades for someone to either fix it properly or, as eventually happened, force it into sudden, undeniable, public view all at once. Sarah, when I mentioned this new letter to her, immediately saw the larger story it suggested. A decades-long chain of quiet negligence. One family's flawed original design. Another family's desperate attempt to hide its consequences behind an expanded, camera-ready fairway. All of it eventually undone by the same water it had always mismanaged. She published a follow-up piece that fall, tracing the original 1990s grading certification back through county archives, confirming the connection to Richard's family firm, framing the entire saga as a single continuous story stretching across 3 decades, from flawed original construction to the very public flooding that had finally exposed it. The state licensing board's investigation into the original certification moved slowly but steadily, eventually resulting in a formal reprimand against the long-dissolved firm's remaining licensed principals, a largely symbolic consequence given the passage of time, but one that closed, finally, the last loose thread connecting the entire saga back to its true origin. I found myself reading that final reprimand notice, thinking less about Karen or Richard specifically and more about how much smaller problems become when addressed honestly and early, versus how enormous, expensive, and public they inevitably grow when buried instead beneath fines, pressure, and fabricated votes for years at a time. The golf course's corrected drainage system, the one I'd consulted on, performed exactly as designed through 2 subsequent rainy seasons. No flooding, no pooling, no repeat of the chaos that had once sent sponsors scrambling in ankle-deep water during what was supposed to be a pristine anniversary preview round. Millbrook Ridge's general manager, in a brief statement marking the club's 27th anniversary tournament, credited the corrected drainage work specifically, without naming me directly, for allowing the charity cup to finally run without incident, the veterans nonprofit receiving its largest single-year donation total in the tournament's entire history that season. I attended that anniversary tournament as a guest, invited informally by the new general manager, walking the 8th fairway on dry, solid ground exactly where to. Years earlier I'd stood watching my own deliberately released water spread across land that had, for one crucial afternoon, refused to keep anyone's secrets any longer. Karen's restitution payments, according to court records Renata still monitored occasionally on my behalf, continued arriving on schedule, the HOA's reserve fund fully restored well. Ahead of the original court-ordered timeline, every dollar Karen had once diverted eventually finding its way back to the community she'd claimed, for over a decade, to be protecting. I sometimes wondered whether Karen, wherever she'd relocated, ever thought about that specific Thursday afternoon, the exact moment her carefully controlled world had begun, irreversibly, to come apart, or whether she'd built some other version of the story for herself, one where she remained, somehow, the wronged party throughout. It didn't matter much to me either way. Honestly, the documented record existed independently of whatever story Karen told herself, filed permanently in county archives, court transcripts, and Sarah's published series, available to anyone who wanted the truth rather than whatever version made a difficult person feel better about difficult choices. Priya, still leading the HOA with a level of transparency that had become, remarkably, just the ordinary expectation now rather than a radical improvement, told me once that the hardest part of her tenure wasn't fixing what Karen broke, but convincing longtime residents that the fixes were permanent, not temporary, not reversible, that skepticism faded gradually, replaced by a kind of quiet civic pride, residents attending meetings not out of fear anymore but genuine interest, volunteering for committees, reviewing budgets themselves, the entire culture of the neighborhood shifting slowly from compliance and silence toward something closer to actual, functioning community governance. I found myself, 3 years after that first certified letter arrived, serving briefly on the HOA's infrastructure committee myself, reviewing drainage and flood mitigation plans for a small subdivision expansion under consideration, ensuring, this time, that every structure approved carried the kind of documentation that could never again be quietly dismissed as a technicality. Mia teased me occasionally about becoming exactly the kind of engaged, detail-oriented resident I'd once resented dealing with during Karen's tenure, though we both understood the difference clearly. Engagement built on transparency and shared information looked nothing like the quiet, unilateral control Karen had exercised for over a decade unchecked. Lily, now old enough to understand more of the story, asked once why Karen had done all of it. The fines, the fake vote, the pressure. I told her honestly that some people mistake authority for ownership, forgetting that a title, even an important-sounding one, never actually grants the right to hurt people freely. That answer seemed to satisfy her curiosity, at least for a 5-year-old's attention span, though I suspect she'll ask more detailed questions again someday, and I intend to answer them honestly, the same way the documentation itself had always been honest, plain, and, eventually, completely undeniable to anyone who finally looked at it directly. The dam still stands today, quietly doing exactly what it was designed to do, holding back just enough water to keep our land dry and, unintentionally but permanently, serving as a reminder that sometimes the smallest, most overlooked structures turn out to be protecting far more than anyone originally realized or intended. I think about the entire ordeal now mostly in terms of what it taught me rather than what it cost me. The value of documentation, the danger of unchecked authority, the quiet courage it took for Priya, Francis, Sarah, and eventually an entire neighborhood, to finally stop looking away from something everyone had sensed for years. Renata closed her file on my case permanently that final autumn, telling me, almost fondly, that she rarely got to see a case resolved so completely. Every thread followed to its natural conclusion. Every wronged party eventually made whole. Every falsified record eventually corrected in some public, permanent way. I told her the credit belonged to more than just me, to Priya's quiet forwarded emails, to Francis's stubborn shoebox, to Sarah's willingness to stand in wet grass, with a camera at exactly the right moment, to Denise's patient explanations of jurisdiction, to Mia's steady insistence that I document everything from the very start. Renata smiled and said that was usually how it worked, that no single person ever really dismantled something like Karen's decade of quiet control alone. that it always took a slow accumulation of small, brave decisions made by people who simply refused, individually and then collectively, to accept things as they'd always been. That felt true. Sitting with it afterward. More true than any single dramatic image of flooding water or courtroom verdicts. The real story had always been about a neighborhood slowly, painfully, relearning how to ask honest questions of the people it had trusted. Unquestioningly, for far too long with far too little oversight. I still drive past the old HOA office occasionally, now relocated to a smaller, more modest space under Priya's more efficient administration. And I feel, each time, not triumph exactly, but something quieter and more durable, a settled confidence that the system, however slowly, however imperfectly, had ultimately worked the way it should. Mia and I marked the 3rd anniversary of the flooding quietly that summer. A small dinner at home, Lily already asleep, the two of us talking not about Karen or the lawsuit or the trial, but simply about the pond itself, the fish we'd eventually stocked, the small dock we'd finally built for Lily. Some nights, sitting by that pond as the sun set, I still find myself running through the entire timeline in my head, not out of lingering anger, but almost out of professional habit, checking the structure of the story the way I'd once checked the structure of the dam itself. For weaknesses, for gaps. I never find any gaps anymore. Every piece holds. The fine, the fabricated vote, the financial filing, the tournament timing, the breach, the article, the audit, the trial, the restitution, the rebuilt trust across an entire neighborhood. All of it fits together now as solidly as the dam that started everything. Frances stopped by again last spring. Older now, moving a little slower, but sharp as ever, mentioning she'd finally thrown away that old shoebox after all, keeping only a single photograph from the emergency HOA meeting where everything had first cracked open publicly. A reminder, she said, without needing all the rest anymore. Priya, still serving as president after her 3rd consecutive uncontested re-election, jokes sometimes that she never expected to spend her retirement years running a homeowners association honestly, but admits, quietly, that watching an entire community rebuild its trust in itself has become one of the more meaningful things she's ever done. I asked her once whether she regretted the risk she took forwarding me those early emails, back when Karen still held total, unquestioned authority over the entire neighborhood. She said no, without hesitation, only that she regretted taking as long as she did to finally act on what she'd already known for years. That honesty stayed with me longer than almost anything else from the entire ordeal. The recognition that even good, decent people sometimes need a specific, undeniable moment, a specific breach, a specific flood, before they finally find the courage to say openly what they'd quietly known and quietly feared for a very long time. Sarah still covers local governance stories occasionally, though her career has expanded well beyond Willow Creek Estates now. The Karen Whitfield saga remaining, by her own account, one of the clearest, most thoroughly documented examples she's ever covered of exactly how unchecked authority quietly reshapes ordinary communities when nobody keeps watch. I keep in touch with her loosely, mostly through occasional emails when some new HOA scandal breaks elsewhere in the county. Both of us recognizing, without needing to say it directly, the strange, specific bond formed by having stood together. Quite literally, in floodwater neither of us fully expected to change so much. Denise, at the county floodplain office, retired 2 years after everything concluded, and I made a point of sending her a short thank you note, telling her honestly that her patient, unglamorous explanation of jurisdiction that first difficult spring had ultimately mattered more to the entire outcome than almost anything else that followed. She wrote back briefly, saying it was, in her long career, one of the rare cases where the paperwork actually got to matter the way it was always supposed to, protecting the people it was designed to protect instead of simply gathering dust in a filing cabinet nobody ever opened again. I think about that phrase often, paperwork actually getting to matter, because it captures something essential about the entire ordeal. That Karen's downfall was never really caused by anger, or drama, or even the flooding itself, but by documentation, patiently gathered, patiently organized, finally allowed to speak plainly for itself in daylight. The neighborhood today looks, on the surface, almost exactly like it did the day Mia and I first moved in. 5-acre lots, quiet streets, the same stand of oaks, hiding the dam from casual view. But it feels entirely different now. Lighter somehow, freed from a decade of quiet, unspoken tension nobody discussed openly. Walt, older now and still living at the end of our street, admitted to me once, over a fence-line conversation, that he'd wished he'd fought back decades earlier himself, over some now-forgotten dispute of his own, before deciding it was easier to simply comply and stay quiet. He seemed genuinely glad I hadn't. "You did what a lot of us should have done a long time ago," he told me, adjusting his hat before heading back inside. It wasn't quite an apology, and it didn't need to be. It was simply an old man acknowledging, honestly, that patience with injustice sometimes runs out for good reason. I think about all of Willow Creek's residents now. The ones who stayed quiet for years and the ones who finally spoke up. Not with judgment, but with a kind of practical understanding. Fear is reasonable when authority appears absolute. It only stops being reasonable once someone proves, definitively, that it never actually was. That, more than the flooding itself, more than the courtroom verdict, more than the newsletter retraction, feels like the real, lasting outcome of everything that happened, an entire neighborhood relearning, slowly and sometimes painfully, that authority without accountability was never actually authority at all. Just habit, unchallenged for far too long. The final piece of the entire saga arrived unexpectedly 2 years after Karen's conviction, when a records request Renata had filed years earlier, mostly out of thoroughness, finally returned results from a neighboring county where Karen and Richard had briefly lived before Willow Creek Estates, revealing something none of us had ever suspected. Karen, turned out, had served on a different HOA board there as well, over a decade earlier, resigning abruptly after a remarkably similar dispute. A residence permitted structure, a fabricated violation, a pressured removal, details buried in old, poorly digitized meeting minutes that Renata's research assistant had painstakingly reconstructed from microfilm archives. That resident, a retired teacher named Harold, had also eventually left the neighborhood under pressure, according to a brief local news mention Renata's team found from that same year. An article noting only that ongoing disputes with association leadership had prompted the sale. No further detail given at the time. Renata reached out to Harold, now in his 80s, living quietly in a retirement community 2 counties over, who confirmed, once he understood who was asking and why, that Karen Whitfield had indeed found him repeatedly over a small greenhouse structure years earlier, eventually forcing its removal despite his own valid county permit. Harold, hearing the full story of what had eventually happened to Karen at Willow Creek Estates, was quiet on the phone for a long moment before saying simply, "I always wondered if she ever did that to anyone else. I'm sorry it took this long for someone to finally catch her at it properly." That conversation added a final, sobering layer to everything. The understanding that Karen's pattern hadn't started with our neighborhood at all. That somewhere, over a decade earlier, an earlier version of this exact story had played out with a different homeowner, a different structure, and no documentation thorough enough to stop it. Renata included Harold's account, with his permission, in a supplementary filing during Karen's sentencing appeal process, not to reopen old wrongs beyond the statute of limitations, but to demonstrate, formally, that the pattern of misconduct extended further and longer than even the original trial had fully captured or understood. The judge, reviewing the supplementary filing, referenced it directly during the appeal hearing, noting that a documented pattern spanning multiple communities and over a decade weighed meaningfully against any argument for leniency, ultimately upholding Karen's original sentence in full, denying the appeal Karen's attorney had filed months earlier. I felt, hearing that outcome, less satisfaction than a kind of heavy, settled sadness, thinking about Harold, about the Alvarados, about Francis, about every resident across 2 different neighborhoods who'd quietly absorbed the cost of someone else's need for total, unquestioned control over people who'd simply wanted to live peacefully on their own land. Harold, through Renata, sent a short note afterward, thanking everyone involved, mentioning he'd finally decided, after all these years, to plant a small greenhouse again at his current home. This time, he joked, with the permit framed and hanging right on the wall where everyone can see it clearly. I found something quietly moving in that detail. An 80-something-year-old man, wronged over a decade earlier, finally feeling safe enough to rebuild the exact thing that had once been taken from him, a small, stubborn act of restoration that felt, in its own modest way, as significant as anything the courtroom had accomplished. Sarah, upon learning about Harold's story, published one final piece closing out her Willow Creek series, tracing the full arc from a $400 fine over a permitted dam all the way back to an earlier, nearly identical dispute involving a greenhouse, framing the entire saga as a cautionary tale about unchecked institutional power. The piece drew attention well beyond the local area, picked up by a few larger outlets covering HOA governance issues nationally, several readers commenting that they recognized uncomfortably similar patterns within their own communities, prompting, according to Sarah, a small wave of similar documentation efforts starting in associations across several different states. I read some of those comments myself. Strangers describing their own versions of Karen, their own compliance spotlights, their own quiet fear of challenging entrenched authority, and felt something unexpected, a sense that this entire ordeal, painful as it had been, had ultimately become useful to people who'd never even heard of Willow Creek Estates. Mia pointed out, reading those same comments with me one evening, that this was probably the most lasting outcome of everything. Not the restitution, not the conviction, not even the corrected fairway drainage, but simply proof, circulated widely now, that patient documentation could genuinely dismantle even the most confidently entrenched abuse of authority. I thought about that for a long time afterward, sitting by the pond as autumn settled over the property. The water level exactly where it should be, the structure holding steady after years of quiet function interrupted by one deliberate, necessary breach that had ultimately protected far more than just our own 5 acres. Lily, playing nearby with a small fishing net Mia had bought her, asked at one point whether the water was the famous water, a phrase she'd apparently picked up from overhearing adult conversations about the story over the years. I told her yes, it was, and that someday I'd tell her the whole thing properly. For now, I told her only the part that mattered most at her age. That sometimes doing the right thing takes a very long time and a lot of patience. And that it's always worth it, even when it's hard. Even when other people insist you're wrong simply because they hold more power than you do. She seemed satisfied with that answer, returning to her fishing net. The late afternoon light settling gold across the pond's surface. And I found myself, watching her, feeling something close to genuine peace for the first time in longer than I could easily remember since that first certified letter had arrived years earlier. The Neighborhood Association, under Priya's continued leadership, established that year a small annual scholarship fund, named quietly and without much fanfare after no particular person. Simply the Willow Creek Community Trust Fund, supporting local students pursuing engineering or public administration degrees. A subtle nod, everyone understood, to how this all began. I contributed to that fund every year since its founding. Alongside Francis, alongside Priya, alongside several residents who'd once been too afraid to speak up during Karen's tenure and now, freed from that fear, found small, meaningful ways to reinvest in the same community that had once nearly driven several families away entirely. Karen's restitution payments concluded fully that same year. The final dollar returned to the HOA's reserve fund exactly as court ordered, closing, financially at least, the last open thread of the entire saga, though the lessons it left behind continued circulating well beyond any single ledger entry or courtroom transcript. I don't know, even now, exactly where Karen lives, and I've stopped wondering much about it. The documented record exists permanently regardless, filed where it needs to be filed, available to anyone who ever needs to understand exactly what happened here, and exactly why one deliberately timed breach eventually mattered so much. Renata told me, during our final conversation closing out the last of the paperwork, that she still occasionally cited my case, anonymized, when advising other clients facing similar HOA disputes, using it as a clear example of how patient, methodical documentation could eventually overcome even seemingly unbeatable institutional authority given enough time. That felt like an appropriate final legacy for the whole ordeal. Not a story about revenge or satisfaction, though there had certainly been moments of both along the way, but a practical, documented example that other people, facing their own version of Karen someday, might actually be able to use for themselves. Mia and I built that small dock the following spring, exactly as we'd planned, Lily's fishing lessons beginning in earnest that summer. The pond finally becoming, fully and simply, what it had always been meant to be before any of this started. Quiet, functional piece of our family's ordinary, peaceful life together. I still check the county floodplain records every spring. A habit now rather than a necessity. Confirming the dam's designation remains active, permanent, protected. A small ritual that reminds me, each time, how close an ordinary permitted structure came to being erased entirely by someone who mistook a title for total, unquestionable authority. The oaks around the dam have grown taller in the years since, their shade stretching further across the water each summer. And I find myself, most evenings now, simply sitting there quietly with Mia and Lily, no longer thinking about Karen at all, just watching the water do exactly what it was built to do. That, I've come to understand, is the real ending this whole story was always working toward. Not the flooding, not the trial, not even the restitution, but simply this, ordinary evenings by ordinary water, finally undisturbed, finally safe, finally, completely, entirely our own again after everything it took to get here. In the years since, Willow Creek Estates has become something of a quiet model for HOA reform in the county. Priya occasionally invited to speak at regional association conferences about transparency, recorded votes, and independent financial audits, always crediting, when asked, the residents who'd refused to stay silent when it mattered most. Frances passed away peacefully 2 winters ago, and at her request, the small memorial gathering was held by the pond, family and neighbors alike remembering, alongside quieter personal stories, the stubborn shoebox and the quiet courage that had helped crack open a decade of silence none of us had known how to end alone. I think of her often now, especially in early spring when the runoff swells against the dam exactly the way it did that very first difficult season. A reminder that ordinary vigilance, sustained patiently over time, remains the only real defense against the kind of quiet, confident abuse of power that so easily goes unchecked. Lily, 12 now, understands the full story these days, has read Sarah's original article herself, has asked detailed questions about the falsified vote, the drainage fund, Harold's greenhouse, absorbing it all not as family legend but as a genuine lesson in what documentation, patience, and a willing community can accomplish together. Mia and I have no plans to ever leave Willow Creek Estates, the neighborhood having become, over the years, exactly what it was originally promised to be: quiet, spacious, genuinely welcoming, governed now by rules everyone can see, enforced by people accountable to the residents rather than to themselves alone. The dam still stands, steady and unremarkable, holding back exactly what it was designed to hold back. A small, permanent monument to the plain, undramatic truth that sometimes protecting your own home properly, patiently, and legally is enough, eventually, to protect an entire community from the quiet damage of unchecked power. The END